Hello, everybody. Hello, Ava. Digging right into it. Oh, the gentle take. The gentle take. Nana Laura, you got a train coming your way. Hold on, let me close this for a minute. Hello, Auntie M. Hello, C-Rex. I have arrived. Hello, Nana Laura. Hello, Buzzy Pug, my love. Hello, Jerry Matthew Boyd, giver of treats and gifts. What's the matter, baby? She probably got a tummy ache from all that chicken yesterday. I know I do. Hello, Joey Bag of Donuts. Well, you've got to work. That's no fun. That's no fair. No one wants you to have to work tonight. You should call in. Hello, Eileenie Carlin, honey. Hello, Lisette Annette. Good to see you. Hello, Mortimer Duke. How was dinner? How was the 70th anniversary? We're all so happy to have you here. Hello, Amanda Roderick, sweetie pie. Hello, K. John Boom. Hello, Spider-Man. Hello, Mark Oddie. So good to see you. Hello, Charlie. Good. I'm glad. That's amazing. Congratulations to them. I hope you told them that everyone was congratulating them and rooting for them and sending them prayers. My goodness. Look at that smile. She's got a smile on her. I love when she smiles. Earl was in here. He went running off. And Tiny Kitten and Billy are both outside. I know that because I heard them fighting earlier. Hello, sweetie. Oh, so do you want to start straight into the cases, or should we watch a body cam video first? I came across one. I got like 10 minutes into it. It's a 20-minute long video, and I was like, I could watch this with my friends. It's a cruise ship one. We don't get to see those often. Cruise ship fraud case. Let's do it. Buddy cam. Yes. Good, because I really wanted to see the ending of it. I have no selfish motivations at all. Well, okay. We always see Spirit Airlines and Frontier, and we get so much Walmart, and there's always, the drunk Karen's on the loose. And I was just, oh, there's Earl. I was just, you know, a cruise ship body cam. It's something different. Hello, Patrick B. Good to see you. All right. Oh my. The cops are out to get someone. I agree. This is actually Virgin Cruise Lines. And I bet this lady's mama wished she'd stayed one.
You thought it was going to be free ride here, come on board the ship, charge whatever you want, and you ain't going to get caught. But guess what?
On February 8th, 2024, in Florida, police were called to a cruise ship concerning a woman who had used stolen credit cards to book her journey. Before their arrival, ship security had already taken the woman into custody.
Did somebody ask you to come on the cruise ship and do something?
No, she just, no. No.
She just what?
She just what?
Go ahead.
Nothing.
What did she tell you to do? Whoever she is. Listen,
but it should be my name, though.
Why did the person tell you to come on the cruise today? You've never been on a cruise before. You booked your cruise recently. Who told you to come on the cruise?
Someone booked the cruise, and they told us to, they asked about the excursions, and basically it was something to do to get away.
So someone told you to book the cruise. They booked it for you. Who is that someone?
I don't know her.
How did you find out about her?
So some stranger just...
No, it was on the internet.
It was on the internet. So some stranger on the internet that you don't know
basically saying
hey, I'll pay for your cruise.
If you do what?
If you do what?
No, you have to pay them. You have to cash out money and everything. I never asked no questions, how much or none of that. She told me I need to get some money up front, all that stuff.
So it's through Cash App. So you have the invoice on the Cash App app?
No, not Cash Apps. She stay in the city, so I can actually go up, yeah.
So did that same person tell you to get this?
Huh?
That same person, the Cash App? Same person we're talking about, the lady. Did she tell you to get this?
No, that was for something totally different. Yeah, that wasn't for the cruise.
But what did she tell you to do on the cruise?
Nothing. She asked if we want to go and, to pay her. That's it, that's all.
So what did you pay her? How much?
Yeah.
How much did you pay her?
Huh?
How much did you pay her?
Just a couple hundreds.
You paid her $200 to go on a cruise?
Yes.
Give me a number.
500.
So $500 to go on this cruise today.
Yes.
What did that $500 give you?
Her and to go on the excursions.
Excursions?
Yeah. But we never did the excursions though.
How much did it cost to book a cruise today? How much did it cost?
I don't know. He told me I owed $1,200.
So who's the lady? What's her name?
I don't know her name.
Then how did you pay her?
Because I went through. I don't know the lady name. I barely even know the lady like that. But
so
I
you paid $500 to be on this ship today.
Yes,
even though it cost you over $1,200 to actually be on the ship. So who paid for the difference?
She said all I had to do was just pay for my flight.
So you only paid for your flight?
Yes, and gave her my money.
What did she ask you to do on the ship?
Nothing. Huh?
Yes, what she asked you to do on the ship?
Nothing right now.
No one in their right mind is gonna let you pay $500 for a voyage that's well over $1,200 for you to do absolutely nothing, and you don't even know this person. So
I thought it was a scam. I thought it was, but
How dare you accuse her of being in her right mind?
I did.
Why did you think that?
Because she was saying she could do it and then can't. So.
She said what? Can you repeat that? I'm not sure what you said. Can you repeat yourself?
I thought I wasn't going to be able to do it. But she told me to just book the plane ticket. And then she was like, you gotta leave.
You leave and then what?
Come here.
And then what?
Be on the cruise.
Mm-hmm. And do what?
She said we do the drinking.
Mm-hmm.
Shit, I ain't even did it. I mean, I ain't.
Do the drinking. What
Yeah,
else?
do the drinking, get off the boat, get off the boat, do what we need to do. Other than that, that's it.
Before you said that the lady wanted you to take excursions, okay, but you didn't take them.
No, not today.
Before you ask any question, you have to understand your rights. You have the right to remain silent. Anything you say can be used against you in court. You have the right to talk to a lawyer for advice before we ask you any questions, and you have a lawyer with you during questioning. If you cannot afford a lawyer,
I'm getting locked up.
Let me finish, please.
No.
You have a right to talk to a lawyer for advice before you ask you any questions, and you have a lawyer with you during questioning. If you cannot afford a lawyer, one will be appointed for you for any question if you wish. Do you understand these rights as I've read them to you? I just wanted to ask you some questions. All right? All right?
Yeah.
Okay?
You want the door shut, Austin?
I'm finna get locked up.
We're going to get to that. Fake? Real. Okay?
Yes.
All right? Where's the credit cards?
I don't have any credit cards.
The credit cards you tried to use.
Wait, what you mean? I haven't tried to use anyone's credit card on here.
Huh?
I haven't tried.
Is this your purse?
Yeah. Them not no debit cards on here.
They about to
Are
look
these
good.
yours? This is your purse, correct?
Yeah.
So what were you using to pay for the ship, the drinks, the food?
They said it was already paid for, so.
Well, they have you trying to make purchases because obviously they charge you back.
No, I haven't even made any purchases.
Who's Mark Curry?
That's my uncle. I just was telling him that.
Mm-hmm.
And he should have a
That was your grandpa. You changing the story now?
we could call him.
We got the gimme
Matter of
that.
fact, we could call Danielle Harvey to verify that.
Why do you have a fake ID?
Somebody made that for me a long time ago.
Mm-hmm.
Yeah. I forgot that was even in my wallet.
Yeah, and also to see which card was paid for reservations. Yeah, I'm here. You can help me. I'm here. My CV works. Okay. So our financial
Hello?
accountant will be here.
You there?
He will do the
Hello?
sum experiment.
Hello, how are you? I'm on a cruise ship. How are you? Because it's a fraud case, they were using credit cards that were stolen, and I'm here trying to unfuck it. Something like that. What's up? Probably. Oh, I know. I don't think I'll get there. I gotta undo this thing. I already called Haley on this. Haney had a similar case about 2 months ago.
I gotta go. Call me.
I'm pretty sure unfuck it is an English term.
Yeah. I'll let you know how it goes.
You said the lady that booked the cruise for you with her card?
I guess, yeah.
You guess? You said that she also booked the excursions for you prior to you getting on the ship?
Yeah.
And then what? You were supposed to come aboard, cancel the excursions, so she got the money back?
Yes, no. Is that what was happening? You do know. Was that what you were told to do? What did she tell you to do? Remember how I said we have facts? Okay.
Yeah.
Remember how I said I can continue to give the facts along the way because we know you're not being truthful. So what did she tell you to do with the excursions? She tell you to cancel them?
I just canceled one.
Yeah, so.
You didn't answer my question. She tell you to
Right,
cancel.
that's what she told you to do.
I only
Go
canceled
ahead. She told you to go ahead and cancel the excursions so she gets the money back. Right.
But she they said you can't get money back anyway. I was just on your account.
Why don't you start from the beginning?
Yes.
What happened?
So basically, we're notified from the shoreside office that it was fraudulent activities on the credit card, that it's reported that it's not authorized payment, and then it came to us.
Was this the card they used to book the trip?
So no, it's different card.
Mm-hmm.
So how did you get alerted that the fraud was on?
That's something that you need to check with the office.
So you went and checked the card, but you went and talked to the people? What happened after that?
Ma'am,
They
just set your
let
phone
you know
down,
that the
okay?
card was
Please.
not used.
Ooh, She's in big trouble, huh?
So we don't have the contact with the from shore side. You can see that I don't.
I just need
Yeah.
a coherent story
Yeah.
there.
So basically, we were notified from the office that fraudulent activity was done on the card. We
Okay.
cannot collect the payments
Okay, and that was for charges on board the ship.
and the voyage fare as well.
So it was for the voyage.
Yeah. Was for the voyage. Of course, and it's two different cards are used. One is used for the payment for the voyage,
Mm-hmm.
and apparently the different one is here on board.
A different card that was here. All right.
Um,
But you don't know who the card belongs to that was fraudulent.
No, they're not giving us that. That's from our shore side. Shai Azobel is our chief security officer for the company. They give us only what we need to follow up here. But
So you don't even know the card name on the person's name on the card.
so I think that could be helpful from us. How do you-
Still, they don't have, because that communication that we received was by email, so we don't have all.
Okay.
Can your offshore security advisor get that for you guys in order for us to?
That will be financial department from Sunset.
Would they be? would
So
you
how
be
do
able
you
to
determine that it was her?
They give us the numbers,
Numbers for what?
cabin numbers.
All right, but how do we get to this lady?
So by the booking number and by the
Was she the only one in the room?
yes.
And she was the one. Do you have video of her trying to make these charges?
We don't have that short side. It's everything booking are done pre-voyage.
Okay, so you don't have video of her using the card illegally?
No.
Okay, so all we have is a fake ID. Okay.
Yes, they're
I will show
using.
you, this is the email that we received,
Mm-hmm.
like with the title.
Okay.
Yeah.
All right. Okay, what do you guys want done?
From our side, we will try to charge the credit cards.
Well, it's not going to work.
Yeah,
But see, for me to make a charge, I have to have a victim. I don't have. I have a card that's bad, but I don't have the card.
Okay, you follow up what you need to follow up.
So
I'm-
yeah,
We
she's
just called-
she's not carrying either card made with the voyages or with any of the excursions. She's not carrying.
So you
either.
don't check cards when they come on?
So there is a system how they put online payment if it goes through.
But you, okay, I think there's a flaw there. All right, well, you're going, so let's go. You're being arrested, by the way. And don't touch your phone. Okay? Do you have anything to say?
Can I tell?
No,
Is she?
no.
She okay?
Get her on the fake ID for now. And once they go through her phone and find the interactions between the so-called other, person that paid for their trip, they'll tack on the rest.
So they're all getting kicked off. You're getting charged. You're getting charged with a felony for possessing a fake ID. Yes, that's happening.
Okay.
You got involved in this thing,
Okay.
and this is how it's ending. You knew it was a possibility, correct? They probably told you there was no way they could do that.
Listen.
I'm listening.
The ID didn't have nothing to.
I know, but we're
Okay.
still charging you for it.
Okay.
Do you understand? You got into this.
Okay. All right.
All right, get up.
Can we
What?
can we fucking try to charge this card with her name? Is it
No,
possible?
you don't need to touch my boys. Cause I just told him we could do it, and he just took all day just to do it.
Where's the card you used?
And I don't got no course. I told him he could use if I could use tap. He said no.
Where's the card you used to buy the purchases?
I didn't do it. Somebody else did it before me.
Mm-hmm.
They're not willing to give that
Can I
person-
let her know that I'm
You're under arrest. All courtesy is gone.
okay?
You been arrested before?
No,
Never.
traffic ticket.
Picked a fine felony to start with.
That's it. How long I'm gonna be
We
like
will
this?
provide
Not
you
my problem.
from the office. They will provide you.
You want to help yourself? Start talking. You don't want to help yourself? I don't really care. You got yourself into this mess. They told you what's going to happen, and they told you how to do this whole scam. You understand? Do you?
Yes.
You're a big girl. You understand exactly what happened. You thought it was going to be a free ride here, come on board the ship, charge whatever you want, and you ain't going to get caught. But guess what? You're caught.
No.
You want to help yourself? Yes or no?
Yes, you still gonna lock me up for the ID. I ain't do nothing.
Oh, you did something. Listen, look, I can write this report real easy. Credit card fraud on board the ship.
No.
Extremely unhelpful. Didn't want to help herself.
Okay.
Charged her with it. And then I just dump it in. Or I could write in, she was very sorry for what she did. Well, she understood she got involved in a scam. She had no idea about it.
I didn't. That's what I was just explaining to her.
You know,
That I never knew it was a scam, the excursions or.
You knew that credit card wasn't good, and you told them when to do the buyback on that thing. You think that's legal?
Say it again.
The buyback on the cruise excursion. Do you think that's legal?
She said, I thought it was a scam. She said that from the start. How is she claiming now? Well, I didn't know it was a scam. I didn't know anything about it. Everything. Oh, just like, yeah, that's my uncle. Oh, it's my grandpa. She can't keep her story straight, but that's what happens when you lie.
No, I never did a buyback.
When you cancel.
Oh, all I did was the cabana thing for tomorrow. That's the only thing that was canceled. Nothing else was canceled for the pearl selling.
And who gets the money for that?
The man told me that it goes on
The man? Who's the man?
that I came down here to talk to someone at the front desk.
but who's the lady? That's the question, because you told me it was a lady.
Who was that?
Yes,
Who is Ann?
someone that I met through a person.
Yeah, but you see how I said someone who I met. Remember we talked about that. That's not helping. You're not helping yourself. Who is Ann?
Somebody I met through somebody.
Come on, let's go.
I met her.
So before you go, just if you can try to shut the cards for the voyage.
Okay. You can, if you want to. So if he was to charge my cards, then what?
Doesn't matter.
Okay, well put my purse down. Because if you gonna charge my cards, I'm still getting locked up.
Yes, because it's a different felony. It doesn't have to be on this one.
Okay, well no. I don't know. Go ahead. I don't even care.
Did you have any working credit card?
Huh? Can I tell her that I want to be locked up?
On the other side, I have one sailor. What? I have another passenger that was in possession of a small quantity of marijuana. I want to ask if I can hand over
Give
to
it
you.
to the other guy. Okay. I got enough problems with this thing already.
Okay.
Lord, man. Dumping everything on me. Yeah, I know. They keep dumping stuff on me like I'm their personal security. What's up?
That was my
What?
that was my little bit of weed leadership.
Uh-huh.
That's a problem.
Yeah.
I didn't know that.
No,
I'm from Massachusetts.
Yeah, it's a problem.
Catch that up.
Okay. And anything else that you need from them, for sure will be there. Okay.
All this background information about the payment system and everything.
From what coming.
Our site can give you.
All right, let's go.
Yeah, that would be great. 'Cause if we have a name that's associated.
They don't have over there. We don't have here because of the feature.
I call you also for.
Hold on. Hold on. Back up. You know him also.
It's before they left.
You don't go until I say so. You understand?
Okay. Okay.
We have another situation with another sailor that we found him in possession of marijuana.
Okay.
It's small quantity.
You can handle that.
For this amount. And then
Listen. Clear your hallway out there so she doesn't talk to her.
So hit them to don't miss this one.
Yeah.
Get it aside.
I think I got it. Yeah.
Sorry for. Okay.
Come on, man.
I was just trying to tell someone who I came with.
No, you don't get that luxury.
I didn't do nothing.
Yeah, you did. You're using illegal credit cards on board the ship, and you
I
booked the
haven't
ship
used
with it.
it. No, I did not.
And you booked your cruise illegally.
No, I did not. I never booked anything.
I got that card, but she booked the cruise with the last 4 digits. I got it.
Okay, so
All right. So you were on board with cards and none of them worked.
I told him,
So how do you explain that?
thank you.
I asked him, did he use Apple? I mean, did they have Apple Pay or Tap? I asked him. He said no.
You came on board a cruise ship with a ton of credit cards. None of them worked except the one, especially the ones in your name.
Okay.
It has to be in your name.
It is Florida.
Yeah, and Tap is in my name. Apple Pay.
You held them up enough. Let's go.
Okay.
Do you want to take anything else? Phone, anything?
Cruise fraud.
I'm asking you.
No.
You say that about all of them.
Here, let's go through this.
Criminals.
I don't
Can I
need
do?
to
What's
Can I
that?
get that to someone?
Huh?
Would I be able to get that to someone?
You're asking me to help you out when you've been so helpful to me? Is that what you're asking? That's what you're asking me to be. Is me to extend a courtesy to you after you've been so forthcoming.
I've been eating.
Okay? So we understand each other now?
Half ain't doing nothing.
Your purse is coming with us with your phone. All right?
Would I be able to give?
I'm pretty sure she's banned for life for cruising.
Yeah, I think, yeah.
Hope so.
Oh, she floats
27, I'm going to have one 10-15 female.
for sure. She's got 2 inflatables on her chest, right below her chin.
Hold on. Same ship every time. They get hit, and they wonder why. It's not a carnival. It's Virgin. They get hit all the time because they don't have simple, basic security in place, like check the name to the card. You know, if she didn't have that fake ID.
Yeah.
I know.
The woman was taken into custody and charged with possession of a fake ID. She's a prime example of the saying in Florida, "Come on vacation, leave on probation." Do you think law enforcement should have also pursued fraud charges against her?
Yes.
Feel free to share your comments and don't forget to like and subscribe for more videos.
Oh, man. I can't believe that. I cannot believe that. All they got her on was the fake ID. I really hope they pursued more charges later. Oh, that makes me mad. No, Patrick, you cannot. This is not the place for it. Definitely not. All right, guys. Now we can watch some Judge Conlon. I don't know. He hasn't streamed for a long time.
Number 10, People versus Melanie Cloutier, 22-314.
Yeah. Jonathan, I'm sorry, yeah.
Good afternoon, Rob Jico on behalf of Ms. Cloutier. Melanie, would you state your name for the record, please? Judge, we're here for a couple of things. One of them is sentencing. I know there's a violation, or maybe even a warrant out for my client for missing testing. All I can tell you is, Judge, as far as the missing testing, my client is mirrored of medical problems. I did forward an email to Mr. Emmons, try to explain things. I can't condone her missing testing, but my client says that she.
So, Mr. Killawall, I gotta just interrupt you. Like, we've spent so much time on this Cloutier, but here's the deal. I'm not sentencing her today. She's got an active warrant. She's probably going to be remanded right now. So just to before you launch into half an hour eloquent argument about this, there is an active community corrections warrant present right here, right now. So I don't know what to tell you about that. We're certainly not going to proceed on sentencing. That's taken care of.
Judge, I understand what the court has just ruled, but I would just ask the court to please consider, and again, this is not an excuse. She has a myriad of serious medical issues. She has doctor's appointments almost every day of the week. They take her blood and monitor all the medical issues she has. I would please ask if you would give this lady one more chance.
How many chances do you think I've given?
A few.
I know. And he, I mean, and the chance would have been, in theory, if she had turned herself in on the warrant this morning,
I didn't know I
you
had,
would have arraigned her and maybe dealt with this all on Zoom.
I had Mike so bad. I
So
didn't look
here's
at
the
the
deal,
email.
Mr.
Judge, I'm not sure. I emailed her. I don't know what she's getting through my emails. She had some issues with it's, again, I'm not pointing fingers, Maya Dozier. Regarding the testing, I would just ask if the court please give her a stern warning, and
I would ask you. One option could be that she is remanded and she is arraigned tomorrow by Judge Slay. And if she wanted to do a sentencing waiver, Judge Slay could sentence her tomorrow. But like, this is just, I mean, Mr. Killowell, this is not how this happens. And so I don't know what to tell you, but I kind of have left.
I can't hear it.
You kind of left me no choice.
Please don't remand me.
Ma'am, I wish.
I have a doctor's appointment tomorrow. I can prove documentation.
Ma'am, I wish that I wasn't in this position to do this right now. And I wish this was the very first time I was kind of hearing this from you, but this is like the 40th time. Mr. Killowald has done a bang up job of representing you. And almost at every turn, we have gotten to the very edge of a remand and he has talked me out of it. And I'm frankly at the end of my rope. So I'm ordering you remanded and
Your Honor,
be arraigned by Judge Slay tomorrow. And then once that corrections warrant is taken care of, we can move to the next sentencing date. And if you want to, I'm not sure if Judge Slay would sentence you tomorrow, but if she's willing to do it and you're willing to have her do it, she can sentence you and then we're kind of done with that part. But that's where we are today.
I'm not sure, Judge. I have Judge Slay tomorrow anyway, so I'll be in her court. So if, I'm going to ask her if she'd be released on her own recognizance to attend to her medical issues, but that's all I can do.
I have an appointment at 7 o'clock in the morning. I am not bullshitting you.
Okay, well,
I understand that you are
you're
very.
not bullshitting me, but if you would have ever gone to do any testing, we wouldn't be in this situation.
I have. And I get testing. I have no problem with that's not the problem.
Okay.
Would you like to put me back on tether? Could you put me on house arrest?
Yeah.
I haven't
I've
left the house.
Funny enough, ma'am, I've already ruled.
You're with me.
Good.
Come with me. Thank you, Your Honor.
So I'm gonna need, you just.
Versus Melanie here, 22314 FH.
Yeah, thank you, Jonathan Emmons on behalf of the people.
Melanie Cotier. Melanie, would you state your name for record?
You gotta let the deputies know that you're muted, Ms. Cloutier.
I'm not so sure about that.
All right, Ms. Cloutier, tell us your name. Still can't hear you, which is unusual because you're not muted. So would you ask the deputies maybe to turn up the, well, okay. I literally can hear absolutely nothing, not even a whisper. So
Melanie.
No, we got it.
The value.
Melanie, I think we're okay now.
So,
Can you state-
well, like you understand that if she can't speak, we can't do this today, right?
No, she can speak.
Well, she told me she couldn't. So, Melanie, can you tell us your name for the record? Mr.
You can hear her faking it, that she's pretending. I mean, we heard her cough and we heard her speak to the deputy because I'm sure the jail knows that she can talk, but she motioned for the judge that she couldn't talk because her throat was sore or something like that.
Killwell, what do you want me to do?
One more time, Melanie.
God.
So I think we're gonna adjourn this a week. I am so sorry, Mr. Pillowall. I know that you will get upset at this, but this of all things should be smooth and straightforward. How are we in this situation again?
It's not her fault, Judge.
Okay.
Sorry.
We'll switch you over.
They said they'll switch me over.
Would you give it one more chance, Judge?
Sure, but if there's a moment that happens, like every other defendant here, I can hear. And so what it appears to me is that she's moving her mouth and no sound is coming out and saying she's lost her voice. So if she can do it today,
She left. I'm sorry.
Get to a different room.
Well, you want to pass until we get her back again, Judge?
Sure.
Thank you.
I'm 100% happy to do that, Mr. Pillowall, but you know that I don't have any more patience with this file, so.
Let's call.
Calling docket number 9, People versus Melanie Cloutier, 2214 FH.
Try it again. Good afternoon, interrupt Jake on behalf of Mr. Cloutier.
Yeah, Jonathan Evans on behalf of the people.
Judge, I would say this, an individual in the audience is her friend, and he told me that she had a bad cold and could barely speak.
Right,
Melanie, can you state your name and say it loud?
Cloutier.
Okay.
Melanie, do you feel like continuing today, or would you like come back next week?
Yes, I'd like to continue today, but I'm disappointed that you didn't come see me.
I hear you now, Ms. Cloutier, so that's good news. So you don't have to talk a lot. Save
Okay.
your voice, and we'll get through this, okay?
Okay, thank you.
All right.
Judge, we were in front of Judge Slay on January 2nd. She pled to the violation, the VOP. In fact, the violation, part of it was coming to your court intoxicated. I've sent letters. She has a lot of friends, letters I sent both to the prosecutor and your staff today.
Big picture. We were actually scheduled for her sentencing back in that time and I'm willing to sort of meld the violation to this.
Yeah, that's what we'd like to do.
Need to double down and.
Can't hear you guys.
Okay, so we're
Okay,
kind of
now I
talking
hear you.
about the two things that had happened. One was violation, the bond violation, and the other is
Okay.
your sentencing.
Right.
Mr. Killowall's bringing me up to speed on what happened before Judge Slay, but
Okay.
I'm not necessarily thinking of sentencing you to anything on the bond violation if we can get through the sentencing on the underlying.
Okay,
So-
gotcha.
So
Judge-
sit tight.
And just in my defense, Judge, on December 18th, when we were supposed to be sentenced, she and I sat in the court, outside in the courtroom, went over the pre-sentence report. I did see her before then. We went over it at the day before at the jail. So, I think we're ready for sentencing.
Sure. So Ms. Cloutier, I know that if Mr. Killowall hasn't seen you in the last couple of weeks because of the holidays or whatever, when we were scheduled in court in December, had you gone over the pre-sentence report with him and
Yeah.
were you ready to go then?
Yeah.
Okay. Are you ready to go today on that?
Yes, Your Honor.
Okay, very
She's ready to go, but she's disappointed in Kilowatt for not coming to see her over the holidays.
well. Good. I'm going to ask a bunch of questions. Mr. Killowall's going to be able to answer most of them. We'll
Okay.
get to you and you'll have an opportunity to speak before I sentence you, okay?
Okay, thank you.
Sure. If I get through this, forget the bond violation. Remind me of that so we keep the file clean and release it, okay?
Sure.
All right. So let me start with the pre-sentence report. I've had a chance to go over it, had a chance to review both the narrative part of it as well as there are no, just making sure no sentencing guidelines. So
That's correct.
there's so many letters in the file, Mr. Killowall, now I can't find any of the loose papers in it, but no sentencing guidelines in this case. So let's start with you, Mr. Killowall. I'll change the sentencing date today's date, but are there any other additions, corrections, or deletions other than that?
Judge, where it says pending charges, in 35th District Court, according to my client, her parents went to the district court, tried to pay the $300. I don't know what happened. I'm not sure it got paid, but what she wanted to stress upon the court that she's trying to clean up her act and get all this done.
All right. So I'll just put on the note here that it's unclear, but I appreciate for the record that Mr. Gillowald's saying you're making the efforts to clear this up. Okay.
Yes, Your
I
Honor.
can't change that though at this point. I can't strike that. Anything
Right.
else, Mr. Gillowald?
The jail credit should be, I'm trying to think of the jail credit, that should be changed.
Well, when Mr. Emmons has a chance to speak, you can do the math on that. It looks like she was here on the 18th and that's when she was remanded. So that would
Correct.
be the date to count.
13.
Mr. Emmons, do you have any additions, corrections to the report?
I'll leave it to the evaluation plan on page 1.
Okay.
It sounds like Mr. Killwell might have additional deletions and corrections. So maybe we can come back to him. But the only thing that I wanted to, it says the defendant I'm sorry, just lost it. The defendant admits that she began drinking alcohol at 8 to 12. The defendant reports she would drink multiple times during the week until December 2022. She stopped drinking entirely. Maybe that needs to be updated given the bond violation.
That's probably fair. Any other changes or corrections, Mr. Killowald?
Just a couple, Judge, in that, let's see, 4th paragraph where it says the defendant has never married. She has reconnected with her mom, is currently estranged from her mom. That second last sentence in the 4th paragraph. She reconnected with her mom in October of 2022.
Never married. No one snatched this prize up. I cannot believe that. I'd have expected even, Jerry to have put a ring on it by now.
I think the court would just note that. And then on the next paragraph, she has started for her medical marijuana card application. She just wanted the court to know that. And the last paragraph, Your Honor, Melanie wanted you to know that she's 2 tests away from getting her GED.
Okay, great.
And
Okay.
then on the next page, Your Honor, in the compass narrative on the very next page, CMH denied her and referred her to Life Stance, which she's now able to do Life Stance and would ask the court if she could continue receiving treatment through Life Stance instead of community mental health. It's
I'm not going to strike CMH if they reevaluate her and offer her
compass
services.
narrative.
If she's eligible to receive services, I will.
Did you see that, ma'am?
What's that?
Other than that, Your Honor, we don't have any other changes.
Okay.
I would ask you, I'm sorry, if the court could give some consideration to lesser fines and costs, Your Honor. She's somewhat indigent.
Gotcha. Okay. All right.
Somewhat indigent.
Well,
I'm sorry.
she's able to afford some things, not others.
All right. So, Mr. Emmons, any additions? Sorry. Well, you gave me 1. Anything else?
That's it.
Any in-court victim impacts?
I do not have any.
Any comments on probation's recommendations or anything you want to add?
Wendy, can you talk to with the jail credit here real quick from the 18th of December?
Somebody.
13, it's 84 and 7, should be 91. No, it should be 92.
Whatever they had plus.
Should be 92 days total.
Plus 21 days.
92.
Gilwell, you are spot on your addition. All right.
And just on behalf of my client, that how many times we're in here where,
Melanie just wasn't taking this serious. And I told this to Judge Slade, and she goes, Bob, jail's not a punishment aspect, but I think being in jail has really awoken Melanie's to the realization she's just got to change her lifestyle. With all the medical issues she has, she doesn't need to be in court on other matters.
She showed up to court intoxicated. That's what her violation was. I don't think she cares if she's in jail or not. I don't think that any of it resonates with her. But good advocating on your client.
Ms. Cloutier, anything you want to say before I impose sentence?
I just really like to get this resolved, and I apologize. And I think I've got a better track going on with what I have set forward. I'm also enrolled in the anxiety clinic through U of M. So I'm doing some stuff that took me months to get in to be able to kind of finish up this program that had been started. And now that I'm able to get a better understanding of what my medical conditions are, it also, is concerning to my mental health as well. So I'd like to have an overall better quality of life. So I appreciate it if you, give me a chance to show you guys that I can fulfill my probation and continue forward and not be in your courtroom again.
Okay, I thank you for that. So, Ms. Cloutier, you're an unusual person for me because, in the one hand, like I understand the concept of, alcohol addiction and how that can affect people. You're unusual in that you've got these extreme health concerns that either are related to alcohol abuse or they're made worse by if you have them anyway. And so you're kind of in this situation where I'm worried about you. Like it may seem like I've come off as like grouchy or something like that, but like I'm worried. And the fact that you were intoxicated in court in December, on one hand, doesn't like personally offend me. Like I feel like she did this out of disrespect. But it just does point out, I think, the concern that I have for your needing to get treatment and care so that forget thrive. I want you to live, and then I want you to thrive. So you're on a track where I don't think you're going to survive very long if you continue using substance, given your health concerns right now. So I want to do what I can to assist you. So I want you to understand that. And I'm just going to cut to the chase so it's not any big reveal. Probation recommended that you serve a term of probation for 1 year. Prior to the 18th, I had written in 18 months. That's what I was going to do. Because of the 18th, I'm going to say 24. So I want you to be on probation for 2 years. And I know that may sound like a punishment, but the reason I'm extending that is I want you to have the oversight of our probation department and the assistance of our probation department to help you get through this and get squared up and get your life on track so that you're getting the treatment. I read all those letters about how giving you are. It sounds to me like you're giving and giving to people that need it, and you're someone who needs help too, and you continue to give. But I want you to understand that I don't view probation as a punishment. I view probation as a vehicle for you to get your life stabilized and on track. So that's why I'm increasing the number. It's not because I'm upset that you came into court intoxicated. I'm concerned about that, and I want you to get the help that you need. So in this case, assaulting, resisting, or obstructing a police officer in the attempt, there are no guideline sentencing recommendations. It's a sentence of the court that you serve a term of probation for 24 months subject to the following special conditions. Number one, you must not use or possess alcoholic beverages or other intoxicants. You must not enter bars or other places where the primary purpose is to serve alcoholic beverages for drinking on site, unless the field agent has first given you written permission for your employment at a specific location. Numbers 2 and 3, you must comply with the requirements of alcohol and drug testing directed by the field agent. You must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with the testing procedures. You must present proper identification at the time of testing. Number 4, you must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician or be with anyone you know to possess these items. Number 5, you must complete mental health, domestic violence, batterer intervention, or other recommended treatment following an assessment by a qualified community-based service provider. Number 6, you must complete the moral recognition therapy MRT program. There was some link in the Compass narrative of that program and CMH. You got to complete that program unless there is an exact, similar one through Lifestance, but otherwise, yes. Number 7, you must waive confidentiality and allow any treatment program that you're required to attend to disclose information to your field agent. Number 8, you must not have verbal, written, electronic, or physical contact with Jeffrey Williams, either directly or through another person. And you must not be within 500 feet of their residence, school, or place of employment. Number 9, you must obey all court orders. Number 10, you must not engage in any assaultive, abusive, threatening, or intimidating behavior. Number 11, you must contact the supervising field agent no later than the first business day following your placement on probation or release from jail. Number 12, you must comply with written or verbal orders made by the field agent. Number 13, you must submit to a search of your person and property, including but not limited to your vehicle, residence, and computer without the need of a warrant if the field agent has reasonable cause to believe items violate the conditions of your probation. Number 14, you must report any arrest or loss of employment if you're a resident, the field agent, within 24 hours, weekends, and holidays accepted. Number 15, you must pay a crime victim assessment in the amount of $75 as ordered by the court. Number 16, pursuant to statute, you must pay a $30 supervision fee for each month of supervision or $60 per month for each month of electronic monitoring supervision. You would not be required to pay in Michigan if you were being supervised on these charges in another state. I am going to keep this in place, ma'am. So the goal here is for you to get out of jail, no tether, no electronic monitoring, and no violations, and it's $30 a month, okay?
Okay, thank you.
I will strike condition 17 altogether. I will strike condition 18 altogether. So you do not have to pay those fines and costs. I can't strike number 19. You must pay a $50 state cost as ordered by the court. Number 20, you must not use any object as a weapon. You must not use, own, or have under your control or area of control a weapon of any type or any imitation of a weapon. You must not be in the company of anyone you know to possess these items. You must not own or possess a weapon of any type or any imitation thereof, any ammunition or any firearm component. 21, you must complete a substance assessment and any necessary programming is recommended by the assessment. So, ma'am, you are eligible for early discharge from probation if you complete all required programming and serve half of your probation term. You or your probation officer can request that. That might include a hearing, so that's possible. And then you're also entitled to file an application for leave to appeal. And Mr. Killowald will get you a form that has all the information on how to appeal. One of the things you need to know is if you want me to appoint a lawyer for you to appeal, you have to make that recommendation in writing within 42 days of today's date. So that is the sentence of the court. I think the most urgent thing for you to remember is that you're likely to be released today. It's not even 3:30 yet. When you get out, you got to contact probation tomorrow. Call the main office and let them know that you were released from jail and that you need to be connected to your probation agent. Okay?
Okay, thank you.
Judge, are you going to dismiss the violation?
I am. So as to the bond violation that was previously alleged, I'm just going to dismiss that. I mean, there was an arraignment on it. You were remanded on it. I could call it time served. I'll just dismiss the violation outright.
Thanks, Jeff. Melanie,
Your
call me
Honor.
tomorrow. Melanie, call me tomorrow. I have your appellate form and I have your 2 rings.
Okay,
All
thank
right.
you.
Good luck to you, Ms. Cloutier.
Thanks, Judge.
Thank you.
Okay.
37 and 38 people versus Alicia McKellar, 23708.
Good luck.
Thank you.
Ready, Judge?
Good afternoon, Your Honor. Katie Wismorski.
Good afternoon.
Good afternoon, Your Honor. Robert Killowald. Judge, I just taking over this case from Marcia. I'm on 23701.
the remaining case, Your Honor.
Right. And Your Honor, Ms. McCullough requested at the last minute that she be able to appear via Zoom. I don't know if she's there or not.
I'm right here, Your Honor. How you doing? Happy New Year.
There you go.
Okay.
That's great.
Okay, well, I think today is the final pretrial because we have a jury trial scheduled in a couple of weeks, right?
Judge, I'm going to be asking, I was just appointed the case, so I'm going to ask that matter be adjourned.
And to be fair to Mr. Killawall,
Yes, to be fair.
I have not turned over, there's video in this matter that he needs to review in this case. Also, there is an offer that I think Ms. Renewski is going to put on the record, and that needs to, and Ms. McCullough may not want to avail herself of the offer, but I think in fairness to the parties, they need to be allowed to have that conversation regarding the offer, and Mr. Killawall needs to review all the discovery in this case.
Do you have a call number?
Chime in also, Judge.
Fire away.
Thank you, Judge. Obviously, I don't have any objections to an adjournment. My last conversation with McCullough was such that she was going to request that the court appoint a different attorney for her. She no longer public defender. So if that is what the court would like to grant, then I believe they would likely appoint Mr. Killawall on my file.
So what's interesting about all this, and because I'm a kinder and gentler judge in 2025, let's just take a deep breath and kind of unpack this issue. Number one, I appreciate everyone's coming into court and making all these asks on the record with a jury trial in 3 weeks. But there's no substitution of counsel order submitted. So I've only heard rumors of Ms. Kracher's glorious, prosperous future. For cases, Wald's asking to be appointed. I don't know much about that other than his ask in court. And Mr. Feaster, I appreciate your position and communication with the client, but I don't have anything really before me as far as a request to have Mr. Killawall appointed on both files. And so, and now I'm being faced with a request to adjourn a jury trial that's been scheduled for a long time. So, what is a kinder and gentler Judge Conlon to do with all of that?
Judge, I know I'll jog your memory. You appointed me yesterday. I have your order with your signature on there, so I know that probably just jogs your memory.
And if I can add to that, I think there was some confusion. Ms. McCullough's last court appearance with me, we request on the record that I be allowed to withdraw, and the court granted that request. So, and then the jury trial.
So I just signed the order yesterday, which is why it's not in the file.
Right.
Thank you for that reminder. Okay.
That should buy me some time, do you think?
Dang, Mr. Killawall, I hate to admit when you're right, but okay, all right.
Okay.
All right, so hold that thought, Mr. Feaster. Ms. Rezmirski, what are your thoughts about all this? It seems like we probably do need to address the problem.
Discretion report on that. I wouldn't necessarily want to be coming up to speed last minute. If I were standing in counsel's shoes, discretion in court. To add some things to the equation, if the court is inclined to address the Kevin Moat matter simultaneously, I would appreciate it just because they are co-defendants in one of these files. My best understanding is that both of Ms. McKellar's files and Mr. Moat's file were to all be tried simultaneously on the 22nd. So it tracks for me that if you are to adjourn Ms. McKellar's, I then would make the request that you also adjourn Mr. Moat's, all of it being predicated on this desire that I have that the children only have to testify.
Fair, totally fair. I assume that Mr. Killawald and the fading counsel of Ms. Kracher and Mr. Feaster are not going to object to that request, even though they may, I don't know, again, what the situation is with Mr. Drukas's thoughts on this, but I would be an advocate to not have the children have to testify more than once. So.
Thank you, Judge. And I guess the only other thing I would add is that I filed other act motion in both of Ms. McKellar's files and noticed same for next Wednesday afternoon, the 15th. I don't know if we want to keep that date or move that date in light of the request to adjourn the trial. I guess I defer to counsel and the court.
So I think in order to conclude this, why don't we go ahead and call Kevin Moat's file right now too? I can give you the number.
Katie, you can put, is there an offer on the table you could just put on the
She
record?
gets 2 counts of first degree.
Can you put it on the record?
Actually, it's 3 counts.
Go ahead, Mr.
Edward Drukas on behalf of Kevin Moat.
All right. And Mr. Moat on Zoom.
Mr. Moat is long, should be.
Hello.
There he is.
Hello. How about a
Hello.
video, Mr. Moat?
Yes, sir.
Okay. All right. So as a general rule, people, we're doing things in person. So unless you get specific permission from me to appear via Zoom, you have to be here in person. So just future reference. That's okay for today. But my question is, A, Mr. Drukas, I am hoping you don't have an objection to adjourning Mr. Moat's trial to track with Ms. McKellar's file.
I had that conversation with Mr. Moat. There'd be no objection.
Okay. So then my next question back to you, Ms. Rezmirski. Should we just take up your motion next week and then give constructive dates next week to everything and call that a pre-trial and then just, I mean, I can give you a date now, it's fine, but that'll give us some time to sort of look at. My concern is with two defendants being tried at the same time, I really want to pick a date that it's likely they can go, whether I'm bumping something else or picking a date further out where there isn't anything scheduled.
Absolutely. My request, though, would be that since I have not prepared and filed Mr. Moat's other act motion as well, that I be allowed to withdraw the notice for next week and renotice them when I file Mr. Moat.
Okay, as long as you think that's going to happen in the next couple of weeks, I'm okay with that.
Absolutely. I've had to sort of dive into
No
trial prep.
No criticism there, just wanting to make sure we're keeping them moving. So
we can even keep the 15th as an initial.
no, there's no need to have them come in, or, like if we're going to track them together, we don't need the lawyers and everybody coming in on different days or having them double. So, all right. Ms. McKellar, I guess Mr. Feaster advanced the question or the thought that you might want to have the public defender removed from this case. I mean, I certainly can do that. That's not my normal practice to just do that. And it also doesn't exactly line up that I would simply appoint Mr. Killewald as your counsel on this other case. It would more likely go into the mix of who's on the schedule for court appointments right now. It makes sense to have Mr. Killewald try both. I get that. But I just wanted to kind of, get out there that that's an unusual request to sort of do that. So
Represent her.
is there any strong reason why you don't want the public defender's office to represent you?
Yes, Your Honor. May I explain?
Sure.
Okay. Well, as far as Mr. Feaster, Your Honor, I just feel like this case that has been going on for quite some time. Just the actions that I seen from Mr. Feaster the last court day that I was in person, I observed that he was on the internet shopping for blue jeans, and I took note of that, and I thought that was very unprofessional because I feel like I'm fighting for my life and for my son, and I just didn't feel like somebody that was doing that and showing such careless nature for my case would represent me properly.
So just to be clear though, Ms. McKellar, you are saying that during your hearing, like while we were on the record with you there, he was on the internet shopping for blue jeans?
Yes, sir. I seen it.
Kilowald, okay. I mean, I frankly don't believe that, Ms. McKellar, but I mean, I guess based on your
Okay.
statement, I will order the withdrawal of the public defender and I will order a court-appointed lawyer for you.
That does not sound like Mr. Feaster. I've seen him in a lot of cases. I could not imagine him sitting during a hearing shopping for blue jeans and ignoring his client's needs. It just doesn't seem reasonable.
My suggestion would be, Mr. Kilowald, are you willing to take both cases?
Sure.
All right, I'll appoint Robert Kilowald to represent you in both matters. And then we'll proceed. I'm going to have Ms. Rozmirski, you simply withdraw your notice for next week. Just get Mr. Moat's matter filed in the next couple of weeks, and we'll have all 2 defendants, 3 matters postured for a date. Then we'll go from there.
Thank you. And the court does not need me to file anything official of the motion
That's
to
you.
join or anything along those lines. That's already been clarified for the record.
I believe, I mean, I have, you know, the files identified both having the same trial date. So let me ask defense counsel, do you feel, I mean, I don't want to leave a detail left undone and have that opened up for an appeal later. So everybody's on the expectation that we're having 2 co-defendants in the 2 cases tried at the same time.
That's my understanding. We did request a separate jury.
Right.
Yeah.
Yours too, Mr. Kilowald?
Sure.
Okay. I know you're new to the case, but
I'm ready. I'll be ready.
okay. All right. So we'll see. I'm not gonna, well, I guess I have to schedule a date. So let's do this. Why don't we just set this for the 29th?
For the motion.
Yeah.
That's one.
What day?
So we'll adjourn the pre-trials on all the cases, and we'll just assume that you're going to get all that filed. So we'll do the motions and the pre-trials on the 29th, and we'll give you a firm trial date on that.
January 29th.
So remind me that I said that, though, that the intent, I mean, because on my end, the intent is with 2 defendants and 2 juries. I want to be clear that we are picking a date that's going to be available and we're going to go.
Okay,
So,
pick a date then.
okay.
Thank you, Judge.
All right. Thank you.
Your Honor, just one point of clarification.
I'm going to hold that thought though. Just
Sure, thank you.
I'm going to cancel the jury trial on the 27th on both Ms. McKellar's and the file.
Mine is 24-108.
Right. What?
That is,
You hear all that, Mr. Moat? Did you hear all that, Ms. McKellar?
Yes, sir.
Okay, so I'll see you both in person on the
Could you explain it?
29th at 1:30.
I kind of misunderstood the last part.
All right, so you got to be back here in person on January 29th, and we're having what I'm going to call a final pretrial to give you a trial date since you have a new lawyer.
Okay.
And we're going to make sure that these matters get scheduled together, okay?
Miss McKellar.
Okay, Your Honor, can I ask, I requested a bench trial. I didn't want a jury trial.
Miss McKellar, let me speak with you first. I will contact you by this weekend. I'm going to get Marcia's file and you and I can speak. And if that's what you want to do, I'll file the paperwork.
Yeah, I mean, I'm willing to hear that for sure, but that's the first I'm hearing it. So let's make sure that you and Mr. Kilowald are on the same page.
Your Honor, if Ms.
Okay, Your
Renewski
Honor,
can
thank
put
you.
the offer on, if Ms. Renewski can put the offer on the record, just so going forward, everyone's got a picture of the landscape.
Are you willing to, I mean, are you willing to keep the offer open now that we're adjourning things out?
In light of the changes, I am willing to do that for a period of time. Let's say perhaps at least until the free trial that's been scheduled.
Okay.
The offer has been throughout that Mr. Moat may plead to 1 count of child abuse, 4th degree, no upfront jail, 5 years of probation. That Ms. McKellar may plead to 2 counts of child abuse, 4th degree. She has 2 counts of 3rd in one file and 1 count of 3rd in another file. So 1 count for each file, 4th degree, same deal, no upfront jail.
He's saying fourth degree on both of them?
Fourth, yes.
You're just missing one count, or is she pleading to?
She said one of each.
One count in one file, one count in.
Oh, perfect, just to make.
Two counts total.
Thank you.
All right, I'll see you both back here on the 29th. All right?
Thank
you,
1:30.
Your Honor.
Thank you.
Thank you.
I think we'll take that off.
Numbers 39, 40, and 41, People versus Dolores Strickland, 24924, 24926, 24927.
First case of the people.
Ready, Judge, court of appeals, the public defender, on behalf of Ms. Strickland. Ms. Strickland, please state your name for the record.
Dolores Strickland.
Okay, today is the date and time set for pretrials in these matters. Head scratching to ensue. 24924, we don't have fingerprints, but the other two we do. So not sure how that happens, but just FYI for housekeeping. So we are here for pretrials in each of the cases though. So counsel, what are we going to do today?
Sorry, Judge, I have spoken to Ms. Strickland about this matter, had a long conversation last night. Like I said, she wishes to take the offer that was made, district court, and she waived up to accept. And I had sent them a copy of the police reports for a no contest plea.
Okay.
I can put that on the record.
She's going to enter a no contest plea to child abuse third and malicious destruction of police property, restitution to be determined. And then the other cases, I think, are being dismissed, right?
I think that's correct, Your Honor, and probably the court and counsel are already on board with this, but my understanding is that that's full restitution to all counts even those dismissed.
That's correct, Judge.
Thank you.
All right. Ms. Strickland, you want to raise your right hand to be sworn in?
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right. Ma'am, have you had a full and complete opportunity to speak with your attorney before coming to court today?
Yes, sir.
You understand everything that's going on and what you're going to be pleading to and how that's going to play out and what's going to be dismissed? Are you ready to go?
Somewhat, I guess, sir.
Cool. I'm sorry. Is that a yes?
Yes, sir. Sorry.
Okay. Okay. So I need you to understand that you're going to plead no contest to a couple of crimes. Is that accurate?
Yes, sir.
All right. You understand that even though by pleading no contest, you're not admitting that you did what was alleged, but you're not denying it. And I have to treat that like it's a guilty plea. Do you understand that?
Yes, Your Honor.
Okay. There is some portion of this as an agreement, meaning that you're going to plead no contest to the child abuse third degree. That's in case 24927 FH. And you're going to plead to a
Destruction of police car.
in case 24924, you're going to plead no contest to malicious destruction of fire or police property. And then all of the other counts in those two cases, as well as all of the counts in 24926, are going to be dismissed at sentencing. Do you understand that part of it?
Yes, sir, Your Honor.
Okay. And that there's also an agreement that you're going to pay restitution even on counts that may be dismissed once we determine what restitution is.
Dolores, what did you do? Malicious destruction of police and fire property and child abuse? Wow.
You can either agree to the amount alleged or you can have a hearing on that. But after the hearing, or if you agree to it, it doesn't matter if the other cases are dismissed or the other count is dismissed. You're going to need to pay restitution on that. Do you understand that?
I guess, Your Honor, but I will say that I am living off of a $945 a month check. I've been on SSI disability for 14 years, Your Honor. And I'm homeless.
Okay, the problem is that restitution, I can waive court costs and fines, but restitution is due to the victim. And some of this may be the government, I don't know, but we'll work that out, but you do, it's part of your agreement. So are you willing to do that today?
Yes, Your Honor.
Okay. Those are all agreements between you and your lawyer and the prosecutor. I almost always go along with those agreements unless one of two things happens between now and the date of your sentencing. If you get into new or additional trouble between now and then, I may decide that I don't agree that those other case or that other case or those counts will be dismissed, and you would have pled guilty or pled no contest to these two charges, and you may not be able to withdraw those pleas. So you might not get the benefit of that bargain. Same thing would be true as if I read your pre-sentence report and there's something in it that's so shocking to me that I can't go along with this deal, that I won't. And you, same thing, you might have pled no contest to these crimes. You might not be able to withdraw the plea, and you might not get the other things dismissed. I'm not threatening you that that's gonna happen, but you just need to know that it's possible. Do you understand that?
I'm good about not getting into trouble, Your Honor, so I will agree to that. Yes, sir.
Okay. As other than what's been put on the record, has anyone promised you anything to get you to plead no contest today?
No, sir. Your Honor.
So I'll repeat that. Other than what I just said on the record and what the lawyer said on the record earlier, has anyone promised you anything to get you to plead no contest today?
No, sir. No, sir.
Has anyone threatened you in any way to get you to plead no contest?
No, sir, Your Honor.
Okay. Is the decision to plead no contest yours to make, meaning that you are doing it of your own free will and you are not being coerced into this? Is that fair?
Plead not guilty, but I don't have that opportunity, Your Honor, because of my circumstances. So I guess, yes, Your Honor. Correct.
Okay. Well, that's a bit of a problem.
I'm sorry, but no, I mean, it's like, I don't want this to go on forward no longer. I don't want to go through trial. I don't want to do all that stuff. I've been in here 274 days, Your Honor. So I'm ready to get back to my little life that I do have, Your Honor. So I'm ready to move forward and get this over with. But the no content or whatever would be my response to this. Yes.
I kind of have no idea what's going on right now.
I know, and me too.
My client has some difficulties, Your Honor.
Yes.
Sometimes understanding things. She's been determined to be competent, but I think she was having some trouble getting around the no contest plea portion of what you were asking, Your Honor. So she's willing to plead no contest, but not.
Yes.
I understand. Would it be helpful if we had her transported here for the plea like that? I don't regularly do that, but I'm feeling that in this case it might be helpful.
Try it, Judge. I don't know that it's going to make a huge difference either one, to be honest with you. This is kind of how she was at district court also.
Back to which I can attest.
So my worry, Ms. Strickland, is this. I know what your wish is. You'd like to plead not guilty, but you're pleading no contest, which has the same effect of you pleading guilty. So but it worries me that you say you want to plead not guilty and you're then pleading no contest. So like that's a bit of a red flag for me because you have rights in this matter. And so I know you want to get it over with, but I guess I'm a little worried about going ahead. Do you think it would help you to be in person so that we could have more of an in-person discussion about this?
I'm just, I'm just ready to get this over with.
Okay. So you are proceeding today of your own free will, correct? No one's forcing you to do this?
No, sir. But I do love my family, and I did love my family, and I just can't be around them no more. They're old enough where they know I love them. That's all that matters. That's
okay.
All that matters.
I didn't ask you this before. Are you on probation or parole anywhere? Because this could affect that.
No, sir, I am not.
Okay. You understand that if I accept your plea, you can't come back later and tell me that there were threats or promises that you're not telling me about. In other
There
words, you just told me
wasn't.
there weren't any.
There wasn't. There's not, Your Honor.
Okay. You are pleading guilty to that aggravated stalking, which is a.
I did not know about that. What do you mean?
I'm sorry, that's because I misstated that. That's being dismissed.
Yes,
You are pleading
sir.
guilty to you're pleading guilty to the child abuse third degree, which is a felony punishable by up to 2 years incarceration or probation up to 5 years. And you are pleading no contest to the malicious destruction of police or fire property.
Just because the aggravated stalking is being dismissed doesn't mean it didn't exist.
That is a felony punishable by up to 4 years and or a $5,000 fine. Those are the maximum penalties. That's not necessarily what's going to happen, but you have the right to know that. So did you understand those maximums?
Yes, sir, Your Honor.
Okay. If I accept your plea of guilty, you're not going to have a trial in this matter, and that is going to mean that you're giving up certain rights that you have. I'm going to go over those rights because they are significant, okay?
Yes, sir, Your Honor.
At a trial, you'd have the right to be tried by a jury, to be presumed innocent until proven guilty, and to have the prosecutor prove beyond a reasonable doubt that you are guilty. At a trial, you'd have the right to have any witnesses against you testify in person in front of you. You would have the right to question those witnesses. And if you needed witnesses for your defense, I would order them to be at the trial too. All right. At the trial, you would have the right to remain silent, meaning you could choose to not testify, and that silence would not be used or held against you. Or if you wanted to, excuse me, you could testify at the trial. Do you understand each of those rights and that by pleading today, you will give them up?
Yes, sir. Your
Okay.
Honor.
Couple of appeals rights. If you didn't like what happened at the trial, at the conclusion of the trial, you could automatically go to the Court of Appeals. You could just file the papers and the court would take your case and you would be heard by the Court of Appeals. By pleading today, you give up that automatic appeal, which means then that you are going to, have to file the papers and the Court of Appeals decides whether it's going to hear your case. I don't decide whether you're going to get your case heard. So that's a difference. So if you don't have the trial, you don't get to automatically go to the Court of Appeals. You have to ask the Court of Appeals permission. In the other matter is that sometimes things happen during a trial that give rise to new appeals. Because you're not going to have the trial, you give up those potential new appeals as well. Did you understand those appeals rights and that you'll be giving them up?
Yes, sir, Your Honor.
Okay. If you are not a U.S. citizen, the case could cause the plea could cause the immigration department to take action against your status and seek to deport you. I'm not saying that will happen, but it's possible that it could. So you just need to know that if you are not a U.S. citizen. Do you understand that?
I am a U.S. citizen, sir, my whole life.
Okay, so then that would not apply to you.
Yes.
And then lastly, certain crimes have reporting requirements on the sex offender registry. I don't think this is one of those, but you just need to know that it's possible. Do you understand that?
Okay, Your Honor. Yes, sir.
All right. Counsel, I've had a chance to review the police report that is in the file. Actually, it looks like there might be two. Is there a public safety report? Is that part of it? I mean, I looked at it too.
There are two, Judge. Yeah.
So we've got Ann Arbor Police Department Report 230036893 dated August 25th of 2023. And then there's also Ann Arbor Police Department 24007695 dated 2/20/24. There's also the U of M Public Safety and Security Report that I also reviewed. That's case number 23903033760 dated August 26, 2023. So between all of that, I'm going to ask counsel, do you believe the elements found in the offenses or the elements of the offense in count 1 of 24927 FH and count 2 of 24924 FH are fully supported by the information in those police reports?
Yes, Judge.
Okay. Are either of you aware of any threats, promises, or inducements not on the record?
It's on the record, Judge.
Have I complied with MCR 6.302?
Court has.
You have, Judge.
Okay. I find your pleas of no contest knowingly, understandingly, voluntarily, and actually, hold on a second. I got to ask the big question first, which I didn't. So, ma'am, I just referenced those police reports that I've reviewed, and your lawyer and the prosecutor have agreed that there's enough information in those for me to take a factual basis that you are pleading no contest to these crimes. So, as it relates to in 24927 FH, count 1, child abuse in the 3rd degree, how do you plead to that?
Contest.
All right. And Mr. Feaster is the no contest plea because of civil liability. All right. Ma'am, in case number 24924 FH, count 2, malicious destruction of fire or police property, how do you plead to that?
Your Honor.
Okay. And then I'm going to adjourn 24926 FH to the sentencing date for those dismissals. So, based on your plea of no contest, my review of the police report, I do find there is a factual basis to support taking the plea of no contest to those 2 counts in each of those cases, and I will do so and accept your plea of no contest.
What I don't understand with this case is they just established that her pleading no contest is for civil liability. But they mentioned earlier that part of the plea deal is that she is responsible for restitution even on cases being dismissed. So she's still going to be responsible for the restitution, which is the civil liability aspect of it. So what good is pleading no contest doing for her, really? The judge said at the beginning that this was going to be a real head scratcher. I don't think he meant this part, but this is the part that's got me scratching my head.
Ma'am, you are going to need to do a pre-sentence interview prior to sentencing. Mr. Feaster, do you want to be present during that?
If she wants me to be there, Judge, I don't feel the need, but if Ms. Strickland wants me to be there.
All right.
Chris, do you want me to be there with you?
Yeah, you've been with me this far.
Okay, I'll be there then.
All right. So, Mr. Feaster, I'm going to urge you to work with probation to not delay this because they're understaffed and any delay causes, as you've seen earlier, a problem. So, all right. So, sentencing in this matter will be. January 8th at 1:30 p.m.
So does that mean, Your Honor, that I'm not going to be out before the holiday, before Christmas?
That is correct. You're going to be in until you're sentencing, unless you're making an argument.
Your Honor, I know she wants to be out. I understand the court's desire to keep her in custody, but I know she does want to be out. But the sooner the sentencing date, the better to get this resolved from Ms. Strickland.
All right. If there's any reason to advance that, you can put it on the docket. Otherwise, we'll see you back here on January 8th. Thank you, Ms. Strickland. You're all set.
Thank you, Your Honor.
Thank you.
Five People versus Dolores Strickland, 4924.
Was that you?
Good afternoon, Your Honor. Marie Tanhas, assistant prosecuting attorney on behalf of the people on all 3 matters.
Ready, Judge. Torshio Feaster, assistant public defender, on behalf of Ms. Strickland. Ms. Strickland, please state your name for the record.
There you go, Ms. Strickland. Can you hear us?
Yes, sir, I can.
Okay. Today is a date and time set for sentencing in 2 of the 3 matters and a pretrial in the other, though the pretrial will be resolved at the sentencing. So counsel, are we prepared to go ahead with the sentencing at this time?
I believe so, Your Honor.
Okay. Ms. Strickland, I'm going to ask a number of questions of your lawyer during this, but I want to start with you and make sure you've had enough time to go over the pre-sentence report and know what's in that. And are you ready to proceed with sentencing today?
Yes, I went over it. I know that I wanted to point out real quick, Your Honor, that my daughter did not write that statement. Her daddy did.
I don't think we're there yet.
We're not quite there yet. So I just want to make sure you've had a chance to go. We'll talk about what's in the report in just a second. But if you've gone over it with Mr. Feaster or someone in his office and you're ready to proceed based on that today?
Yes, sir.
Okay. Just to put on the record, it looks like the defendant did plead no contest on November 13th, 2024 in 24924 FH to count 2, malicious destruction of a fire or police property, and in 24927 FH to child abuse 3rd degree. And then what would happen in 24926 FH, the case will be dismissed today at the sentencing. So is that what we are operating under?
That's my understanding.
Yes, Your Honor, that's my understanding.
Okay. All right. So let's start with you, Mr. Feaster, and your client. Do you have any additions, corrections, or deletions to the informational part of the report?
No, Your Honor.
All right. And just to be clear, Ms. Strickland, what we just discussed was there's no changes to the contents of the report. There may be a comment on the requirements of probation or you'll have a chance to explain anything to me, but basically the information that's in the report is accurate. Is that correct?
Yes.
Okay.
Sorry,
Ms. Tana, do you have any additions, corrections, or deletions?
I do not, Your Honor.
All right. Mr. Feaster and Ms. Tana, any challenges to the guidelines?
Not from the people.
I didn't have any either, Judge.
I've had a chance to review the pre-sentence report submitted by MDOC. I'm considering the calculations done by MDOC. I've invited input from the attorneys. I did my own calculations. I didn't have any changes either. So I do find that the calculation of guidelines is accurately done given the information in the report. And at the conclusion of the sentencing, I will sign sentencing information report. I'm dating it right now. All right. Ms. Tana, do you have an in-court victim impact statement on either file?
No, Your Honor, victim impact statement was submitted to the court and the court received.
Right. I've had a chance to review what's in the paper file. I just wanted to make sure there was an opportunity for anyone to give a statement today.
And I apologize. I will add regarding the malicious destruction charge and conviction, as part of the agreement, we had Ms. Strickland agree to restitution on all counts, including the dismissed case. So that will be forthcoming. We don't have those numbers yet.
All right. Okay. And Mr. Feaster, any comments on probation's recommendation? Any allocution on behalf of your client?
Thank you, Judge. I'll try to be brief. This has been a long time coming to a resolution. Ms. Strickland's been in jail for almost a year, and we've had a lot of conversations during the course of that year trying to get us to this point. I'm glad that we were finally able to get it resolved, and Ms. Strickland was willing to take responsibility in these cases and to try to get everything wrapped up, Your Honor. Obviously, the recommendation is for a probationary term. Ms. Strickland is very honest with me that she has struggled on probation in the past, and she is hoping that she could be successful on probation this time. But she also noted to me that if the court wanted to give her additional jail time in lieu of probation, she would take that also. But I told her that the recommendation and the agreement was for a probationary term, so that's what she's looking forward to, Your Honor. What she would ask, Your Honor, is that the court, she does have financial difficulties, Judge. And so the parts of the report that the financial portion could be waived, she's asking for waivers. for 17 to 18, attorney fees and court costs. And other than that, Your Honor, she's going to do everything she can to be successful and to pay her debt for her actions in these cases. And she's apologetic for what happened, and she's asking for an opportunity, Your Honor.
Okay. Ms. Strickland, is there anything you want to tell me before I impose sentence in this matter?
Basically wanted to tell you that my daughter did not write that statement. Her father did. It's clearly my daughter's not that educated. Unfortunately, but she is still very smart lady. But just basically that I know that I've done 323 days, Your Honor, and this is the longest I've ever stayed in jail. The longest I've ever stayed in jail is 93 days. And this has really hurt me, like physically and mentally, being here. And I would like to ask you, Your Honor, for time served and walk away with a whole new life and a whole new start, because I think I deserve it. I'm too old for this. And I am done with him. I am never going to go back to him again. This has been 15 years too long. And I'm tired of his abuse mentally. And I just want to be done with it. A new slate, a new year, new slate. And I think my daughter should have, be able to speak for herself. So that's basically all I wanted to say, Your Honor.
I mean, the plan is to let you out of jail today, Ms. Strickland. You are going to do probation though, so I'm not going to do just time served. So that's kind of the plan. Does that make sense to you?
Well, I know I'd pay like the $130. And I guess I would have to do for the car, I would have to do community hours, something like that to pay for that. If that would be.
Well, there's a bunch of things that we got to do, and some of them are to safeguard your reentry into society and make sure everything's good there. Some of it's to preserve potentially restitution if that's requested. And some of it is to make sure that you're getting the treatment that you need to be successful. So that's kind of what probation is.
Yeah, also, Your Honor, I got my psych doctor connected back with him. I got an appointment on Monday to see my psych doctor.
Okay. All right. Thank you. As to the malicious destruction of fire or police property, there are guideline sentencing recommendations of 0 to 17 months. It is a sentence of the court that you serve a term of probation of 2 years, subject to the following special conditions. Number 1, you must not use or possess alcoholic beverages or other intoxicants. You must not enter bars or other places where the primary purpose is to serve alcoholic beverages for drinking on site, unless the field agent has first given you written permission for your employment at a specific location. 2 and 3, you must comply with the requirements of alcohol and drug testing directed by the field agent. You must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with the testing procedures. You must present proper identification at the time of testing. Number 4, you must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician or be with anyone you know to possess these items. Number 5, you must take medication as prescribed by a licensed physician. Number 6, you must complete mental health, domestic violence, battery intervention, or other recommended treatment following an assessment by a quality community-based service provider. Number 7, you must complete the Accountable Choices program. Number 8, you must waive confidentiality and allow any treatment program that you're required to attend to disclose information to your field agent. Number 9, you must not have verbal, written, electronic, or physical contact with Isla Strickland and Aaron Kaufer, either directly or through another person. Number 10, you must not engage in any assaultive, abusive, threatening, or intimidating behavior. Number 11, you must contact the supervising field agent no later than the first business day following your placement on probation or release from jail.
No assaultive or abusive behavior, like aggravated stalking or child abuse, stay away from those. Or malicious destruction of property. Can't do that. Can't do that one either.
Number 12, you must allow the field agent into your residence at any time for probation supervision. Number 13, you must submit to a search of your person and property, including, but not limited to, your vehicle, residence, and computer without the need of a warrant if the field agent has reasonable cause to believe you have items which violate the conditions of your probation. Number 14, you must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends and holidays accepted. Number 15, you must pay a crime victim assessment in the amount of $130 as ordered by the court. Number 16, pursuant to statute, you must pay a $30 supervision fee for each month of supervision or $60 for each month of supervision if you're being supervised with an electronic monitoring device. I'm going to suspend those payments upon your successful completion of probation. So if you complete probation, you don't need to pay the $30 oversight fee per month. I will strike outright conditions number 17 and 18, but I can't strike number 19. You must pay the $68 state cost as ordered by the court. Number 20, you must not use any object as a weapon. You must not own, use, or have under your control or areas of control a weapon of any type or any imitation of a weapon. You must not be in the company of anyone you know to possess these items. You must not own or possess a weapon of any type or any imitation thereof, any ammunition or any firearm components. Number 21. You must complete a substance abuse assessment and any necessary programming is recommended by the assessment. I'm adding a condition 22, which is regarding restitution, that even if counts or cases are dismissed, you are ordered to pay restitution if asked on all cases as part of your probation in this case. If you disagree with the amount of restitution claimed, you have the right to a hearing on that, okay? Case number 24927FH, child abuse third degree. There are guideline sentencing recommendations of 2 to 17 months. It is a sentence of the court that you serve a term of probation for 2 years with all of the conditions of probation duplicated in this as they are in the other case. So all the recommendations are duplicates. Ma'am, same deal. Because I'm not asking you to double down on anything except you do have to pay an additional $130 as ordered by the court in condition 14, and you have to pay an additional $68 state cost in condition 18 because they're different case numbers. So I can't waive those, but I will waive all of the other fines and costs and oversight fee in this file. But all the other same terms and conditions apply in both files. All right. Ma'am, those are the terms and the conditions of your probation. Some particular things. First, let me ask you, do you have any questions? Okay. When you are released from the Washtenaw County Jail, which I would expect would be today, you are ordered to contact probation by tomorrow to check in and let them know you were released and that you need to be put in contact with your field agent and have these things get started. So that's one part of the order of the court from earlier today. It's one of your recommendations, just to remind you of that. And then the other piece is that if you complete all of your probation and all the fines and costs, and you complete half of your probation rather, and the required programming, you might be eligible for early discharge. You or your probation officer or your lawyer could file that motion and I would consider it. It might involve a court hearing, not sure. And you also have the right to appeal what happened today. Mr. Feaster will get you an appellate rights form. It has a lot of information about how to appeal and what your deadlines are. The most important takeaway from an urgency standpoint today is that if you wanted court-appointed counsel to represent you on the appeal, you have to make that request in writing within 42 days of today's date. Do you understand that?
Yeah.
So if you wanted to appeal what happened today and you wanted me to appoint a lawyer, you'd have to make the request on the form in writing within 42 days of today. Mr. Feaster, can you confirm that you'll get the form to your client?
I will, Your Honor.
All right, so he's going to get you the form. You can read it, take a look at it, see if you need anything on it. Otherwise, I think we are done. So if you don't have any questions, that'll conclude the hearing. Okay, you're all set, Ms. Strickland. Thank you.
I am surprised that that she's out, or that she didn't violate. We got a little trivia going on in the chat because apparently Charlie looked her up So did Manuel. So my guess was 48. We got Jerry saying around 40. Nana Laura giving her way too much credit. She's 44. She's a rough 44. He won't. He won't. We won't let him. Yeah, she definitely looks older than 44. That is for sure. I was born in 82. So she's a year older than me. I'll be 43 this year, or what, in 26. Yeah, I just turned 43. Just turned 43. Yeah. I can never remember. Yeah, that would be my downfall. If they pulled me over for drunk driving and asked me how old I am, I'd be like, I don't know, like in my 40s ish. Oh, I remember Rosebud. I actually have a music montage of Rosebud. Wait, is she really? No way. She does look like. No way. You guys should go check out my music montage of Rosebud though, because I'll put it in the description. I actually bought the license to use the song that I made that montage with. Oh, that's wild. Oh, I will definitely have to make a playlist of her then. She's gonna have to be an FTC because we did 2 cases there, and then I have the Rosebud case. So yeah, that's the FTC. I do. I almost put them on tonight. Right before my shower. But I put my diabetic socks on instead because my feet are a little bit swollen. Oh, sweetie. There is technically one more case, but I am going to fall asleep through it if I put it on. I'm sorry. Because it's 3 hearings, but we can watch it tomorrow. Oh man. That is crazy. But I mean, he's an actor, so they made him look the part. But that is wild. Oh, well, don't forget that you can also listen on Spotify. So for those who like to keep it playing in the background, if you have a Spotify account, you can watch or listen on Spotify. Yeah, it's under the PAWFURM. All right, guys. I'm going to go to sleep. And hopefully I will see you all tomorrow. Thank you for coming and hanging out with me and making this the best night. Oh, hold on. I gotta fix my hair. Because I can make replay crew minis out of this. I love you guys so much. Be safe, be well, sleep sweet, and much love.